Civil justice system. The chapter is tested almost every year in Paper 1. The question comes in the form of a problem question most often. Moreover, you must know that there can be 5 types of questions from this chapter. 1. ADR, here you discuss negotiation, mediation, conciliation, arbitration, courts and tribunals. 2. Methods, here you talk about ADR, courts, and the methods. 3. Courts, here you discuss how a civil proceeding goes about. For appeals, here you must talk about the courts and ADR briefly and then assess and critique the appeals. 5. Legal aid, here you discuss the problems that might occur due to costs and how legal aid is good or bad. Ensure to critique. As already pointed out in Chapter 1, it is necessary to consider the distinctions between civil and criminal courts. Civil proceedings address a wide variety of problems, and there may be a really clear description that can encompass all of them. However, the simple concept of civil lawsuits is that they occur when a person or a company feels that their privileges have been infringed in any manner. 4 of the major fields of criminal law are contract law, tort law, family law, employment law, and business law. As well as engaging with various fields of law, the kinds of conflicts that can occur in the context of civil law are similarly varied. A business can argue that it owes money. Contract law, this form of allegation could be about a few pounds or 100 million. A person may seek remedies for the damage sustained in the event of an incident, torture of negligence, while in another situation, the lawsuit will not be for damages but for another remedy, such as an injunction to prohibit anyone from building on the contested property. Certain forms of court decisions include a winding up of a business that cannot meet its creditors or a dissolution decree for a marriage that has collapsed. The countdown is nearly endless negotiation. In most legal proceedings, individuals consider a court case as a last resort and may seek and settle the issue without heading in trial, such that, when a conflict occurs, a kind of settlement is likely to take place. The most popular case is that the person presenting the complaint either goes to visit the other side and discusses the issue. This is normal when shoppers carry back the non-standard goods, or sends a report to the other side. Many disputes can be settled at this point, with the other party deciding to repay the money, alter goods, settle the debt, or take some such measure. The desire to seek and settle every conflict is illustrated in the pamphlets provided by the Court of Justice regarding proceedings in litigation. I'm in a fight with their leaflet, what should I do? Shall contain the following information. Do all disputes have to be settled in court? No. It will usually be the last option to go to court. It can be costly, difficult, and time-consuming. You will still seek to find an understanding before heading to arbitration. For starters, if you are in disagreement with an entity, you can follow the organization's litigation process before you start filing a lawsuit for the trial. If you bring a lawsuit to the court without even taking any attempt to negotiate a compromise, you may notice that the judge may be keeping the allegation against you while deciding the recovery of the costs of the trial. You cannot have the expenses back, or the judge can require you to compensate the expenses of the other side, even though you win the lawsuit. Some forms you could attempt to achieve an arrangement involve mechanisms such as consultation, mediation, and arbitration. These are also more casual than trial hearings. Legal advice. And if the other side refuses to resolve the dispute, the aggrieved individual must determine if he or she is willing to pursue the matter forward. The most likely next move is to seek legal counsel and maybe get a prosecutor to talk to the other party. It can contribute to a bargaining scenario where a variety of correspondence is exchanged between the sides, and a settlement is eventually achieved. However, if, despite all this, the other party fails to pay the debt or compensation, or whatever else is alleged, the aggrieved individual shall pay the debt or compensation. It has to determine if the issue is worth exploring even more. This could include beginning a legal case, or an alternate method of conflict settlement can be used. These options to heading to trial are mentioned in the next chapter. Going to court. Bringing a case to trial will be a daunting practice, particularly though you intend to play it yourself and do not have a lawyer. There will be a trial charge depending on the form and amount of the lawsuit that may be taken back by the opposing side should you win the case, although there is also a chance that you will lose the case and continue to cover the expenses of the other side. And if you qualify, the troubles will not be solved, because the other party does not have enough funds to settle the fee to cover the expenses. When the situation is complex, it may take years to finish, and it might cost hundreds of thousands of pounds. In spite of these issues, it is not shocking that even individuals who think they have a fair argument opt not to pursue legal action. Nevertheless, beginning a legal dispute does not mean that it necessarily goes to trial. The overwhelming majority of lawsuits are decided out of litigation such that fewer than 1% of the proceedings taken to the federal courts proceed as far as trials. It is because the conflict is a private matter between the individuals involved, so they will resolve their own disagreement at any moment, even after the hearings have ended.